Well, thank you so much for joining me today. This is my first webinar, so from my perspective, I feel like I'm just sitting in my office talking to myself, but I know there's some folks out there, so thank you so much for investing the time in talking about and listening to this presentation on informed consent and confidentiality and its exceptions. I'd really like to focus on Utah Psychologists, so the Utah Licensing Act, and we'll be talking particularly about that today. The way that I'd like to handle questions is apparently you can either electronically raise your hand and Jamie will see that, or there's also a chat box where you can type questions in. I've got a lot of material to get through today, and so I'm hoping to reserve the last 5 to 10 minutes for questions. So I'm just going to, I think, push on through, and hopefully we'll have some time at the end for questions. So I'd like to begin by saying that the UPA and the Early Career Psychology Committee wish to thank the Trust for their generous support of this webinar. It's their support that makes this possible, makes possible your free participation. That's been true for every webinar of this season. I'll also mention that today I don't have any commercial interest in any materials or resources that I'll mention, and I'm presenting today on a volunteer or pro bono basis. And I'd like to especially thank Jamie Brass for her assistance and asking me to speak and getting the webinar set up today. So getting started, you know, my own background, I've been practicing at the University Counseling Center at the University of Utah for many years, more than 2 decades now. I also have a teaching appointment here at the University of Utah in the Educational Psychology program, where I've taught standards and ethics for the last, I think, 8 or 9 years. And today's webinar, again, we'll go for an hour. We'll look to end at 1. I'm hoping to save the last 5 to 10 minutes for questions. You know, as I was putting together the webinar for today, it occurred to me that I really think this could almost be a day-long webinar. There's a lot of information. I've tried to pare it down. There are several resources and links that will be included on the slides today. And my hope is to give you an overview and an outline of this important topic, to give you some resources and links, again, that you can perhaps follow up on your own if you're interested. And I'm happy to share these slides with anyone who would like them. Just email me, and my email address is appearing there below. So just email me, I'll send you the slides, and I'm happy to share those. My email address will also come up on the last slide of the presentation, so you'll have another chance to write that down. And then some caveats and provisos. Again, we've got more material than time today, but I'll try and keep us moving. I'm going to talk about informed consent, particularly as it relates to confidentiality, which is our other topic today. While I have some knowledge and expertise in this area, I'm not infallible, and in fact, I regularly consult when it comes to matters of confidentiality, you know, particularly mandated reporting, even if it seems simple or straightforward. So that's important to keep in mind. And then finally, I'm not an attorney. Today's information will be my understanding of obligations that we have as psychologists, but I'll not be offering legal opinions or advice. So with those caveats and provisos, let's go ahead and jump in. So Stephen Banke, who chairs the APA Ethics Committee, has come up with a strategy of thinking about issues that come to his attention when he's asked to consult, and specifically thinking about, you know, what kind of an issue is this primarily, and he's come up with what he calls his 4 bin strategy, his 4 bin approach. So there's our 4 bins. So, you know, sometimes issues that will come to his attention he sees as being primarily legal questions. Sometimes, of course, being that he's the chair of the ethics office, the questions are ethical in nature. Sometimes they're primarily coming from a risk management perspective. And other times, situations really have more of a clinical implication or clinical bend. So these four approaches are not mutually exclusive, but they are just somewhat different perspectives. And that's something I wanted to mention as we start out today, that that good ethical practice, most often, of course, is consistent with good legal practice, with good risk management, and providing the best clinical services that we can. And the same is true from those other perspectives, so there's quite a bit of overlap. And today, particularly in talking about confidentiality, we'll be looking at Utah statutes and obligations that we have as psychologists in Utah, so we'll be coming a little more from this legal angle or bent. So for those of you who might know Ted Packard, Ted is a wonderful human being and my mentor, and Ted has a great way of, I think, distilling kind of complicated, complex situations into their essential elements. And so in talking and thinking about informed consent, Ted identified that there really are four essential elements. The first is to determine that the client is of age and is competent. So the age of consent, informed consent for treatment in Utah is 18 years of age. So if we're working with someone who's not 18 years old yet, we need to be aware of that and take appropriate actions. I'll talk more about that. So the client is of age and competent. The competence piece, there are legal definitions of competence. For today, I'm going to use, I guess, kind of a working definition of if a person has the mental capacity to understand treatment and to participate in their treatment, toward their own best interests, then they would be deemed competent for those purposes. So that's the first criterion. And then material information is disclosed to the client. We'll talk more about material information in a moment. There needs to be some kind of a process by which we determine that the client understands that information, or at least we need to assess that as best we can. And then finally, that voluntary consent is given based on the information that was provided. And again, we'll be focusing primarily on that material information disclosed to the client, again, surrounding confidentiality. So, some of the specific elements of how you provide informed consent may vary by your setting and the nature of your practice. But just as an example, in my own work here at a university counseling center, we start by introducing written materials first. This is if someone's coming in for an intake appointment, for example. There are some written materials. I think it's important to clearly explain the rule of confidentiality. Sometimes when I'm doing training or working with the supervisee, I'll notice that they might be jumping right to the exceptions to confidentiality as a way of introducing that topic. I think it's important to explain the rule of confidentiality first. And then, of course, explaining the main legal exceptions to that rule. And in my practice, and as I've reviewed the Psychology Licensing Act, those main legal exceptions really fall into four categories. So child abuse, neglect, exploitation, vulnerable adult abuse, neglect, exploitation, duty to warn, protect self and others, and then a category that I'm calling certain legal processes and obligations, and I'll speak about each of these in turn. And then again, in that process of providing informed consent, encouraging questions and follow-up as needed. So as we think about providing informed consent, there are, of course, ethical obligations that are triggered in that process. And just looking at the APA Code of Ethics, I think it's worth reviewing the Code 3.10, which deals with informed consent generally, emphasizes that we need to use understandable language for those that are legally incapable of providing informed consent. So for those who are not yet 18 years of age and or who may not be competent to understand or participate in their treatment, we still need to provide an explanation of our services, of what we're doing, what we're intending to do. We need to seek their assent, respect those individuals' autonomy, and still obtain appropriate permission from a parent or legal guardian. Of course, there are some special circumstances where informed consent is altered, or even when we don't have an obligation to provide informed consent as we normally were. Those circumstances would include things like court-ordered treatment, court-ordered assessment work, mandated work, and then sometimes in research applications, the full informed consent process doesn't happen at the outset. It actually may happen during the process of collecting some kinds of research data. And then, of course, there's an obligation to document written or oral consent, permission, and assent. So that's, again, coming from the APA codes. In Section 10 of the codes that has to do with psychotherapy, there's another code, 10.01, that talks about providing informed consent in therapy. That code mentions providing informed consent, quote unquote, as early as feasible, that we should talk about the nature and anticipated course of therapy, about confidentiality, its limits, fees, relationships with third-party payers, etc. The ethics codes also include the importance of providing an opportunity for questions and answers. And for those of you who may be trainees or are still being supervised, there's actually an ethical obligation that you have and that we all have to see that you disclose your trainee status and that you give the name of your supervisor to the client. So again, those are just a few kind of ethical obligations that we have around providing informed consent. So other considerations with informed consent, we can think about, well, when does informed consent take place? And I think the common thought and the common answer is, well, at the beginning of therapy, and certainly that's true. Our ethical codes advise us to do this as early as feasible. However, I think informed consent really takes place not only at the beginning of therapy, but really maybe at multiple times during the session and really across the course of sessions. So I think our big informed consent, our kind of big formal informed consent procedures, would take place normally at the first session, even prior to the first session. But I think that really happens all the way along, which addresses this next point. Is it more of an act or more of a process? As you can tell, I'm really thinking about and approaching informed consent as more of a process. If we think about working with a client, for example, and we have a client come in and we've been pursuing a particular form of treatment, a particular modality of treatment, the client may come in and complain of a lot of stress or anxiety. You might think it helpful to do a brief relaxation exercise with that client. It might be the 3rd or 4th or 10th session, but you've never talked about that before. It would certainly be appropriate to have just a brief process with that client around informed consent. I notice you're feeling a little anxious and stressed today. I have a technique that I think may be helpful for you. It's called systematic relaxation. It would involve the following steps. It would take about 20 minutes. Here are risks that might be associated with that. Here are the benefits that I think would accrue, and here's why I'm thinking about this for you today. Would that be all right with you? So that didn't involve paperwork. It was a verbal process. It happened in the course of therapy, but that's an important example of informed consent. So again, it's not always a written process. However, really whenever we do seek the consent of our clients in proceeding, I think it's important to document that in a case note. So I would just invite and encourage all of us, each of us really, to review our informed consent practices, both the formal written practices that tend to happen, more in those early phases of therapy, but also these sometimes informal, often verbal instances of informed consent that really, I think, should be happening throughout our interactions with clients. So just thinking about informed consent for another few minutes, just some resources and some sample documents. So the Trust, which again is helping sponsor this webinar series this year, has some nice resources. There's a link here, and I'm hoping that this link is going to be live, and indeed it is. So here's the Trust. This was formerly the APA Insurance Trust, now just the Trust. It's a wonderful resource whether or not you carry liability insurance with this provider. But you'll see here that there are quite a few insurance applications, but I'm going to direct you to the resources here. There's a sample informed consent form or a psychotherapist contract. For those who might do or be doing forensic work, there's a sample consent form, an outpatient services agreement. For collaterals, that would be for family members or friends who might become part of the treatment in some way. There's a coaching contract, a child therapy contract. I'll talk a little bit about minors in a few minutes. But as you can see, there just are a number of resources there around informed consent and that documentation. Another great website, another really good resource is Ken Pope's website. I don't know if any of you are familiar with Ken Pope, but he's a very prolific author and in the area of ethics, and has a wonderful website that I visit not infrequently. And this is Ken Pope's page around informed consent in psychotherapy and counseling. So again, this would be, I think, for your future reference, but there's he actually cites this insurance trust sample contract. Last time I clicked that link, it was broken, which is why I gave you the other link on the previous slide. We'll just pull this up for a moment. This is Laura Brown's disclosure statement. Dr. Brown is a well-known therapist, feminist multicultural therapist in practice in Seattle, and you can see how she approaches talking about confidentiality and informing the consent of her clients, just as an example. The other resource that I thought I'd share simply as an example, since I'm here at the Counseling Center and have been here for some time, preparing for this presentation got me thinking about, how do we inform the consent of our clients? We actually have a statement on our website around confidentiality that you could review. We do actually talk about the rule of confidentiality first, and then talk about some of those legal exceptions that I mentioned. We've also gone to, in addition to having our clients look at our service agreement on paper and signing that, we've posted it online so that they could review that at any time. So again, those are just a few documents and resources around informed consent. Quickly, a couple of slides about informed consent in minors. So again, when we're working with someone who's not yet 18 years old, we would need to seek parental permission to work with that individual. We would also, however, want to seek the assent of minor clients or other clients who are not capable of giving consent. We need to be aware of that there are different age requirements to waive parental consent for health care, and they vary from state to state. I'll actually have a summary of some of those ages for different forms of treatment in Utah later in this presentation. So when we are working with children or adolescents, it's important to know those requirements for our state. And there are a few exceptions, at least possible legal exceptions to parental consent for minors. The first would be minors who are legally emancipated. In my experience, these young people tend to know who they are. They might be married, they might be in the military, they might be employed, but they tend to know if they have legal emancipation. Parental consent would not be required in that case. Minors who are in true emergencies, of course it would be less than ethical for someone who presents in our doorway to say, for example, I'm feeling very unstable, I think I may be suicidal, I have the means, I have the intent, oh, and by the way, I'm 17 and a half years old. Well, we're going to respond to that person. We're going to help that client and try and ensure her or his safety, and we're going to inform the parents as soon as possible afterwards. So if it's a true emergency, I think there would be an ethical obligation for us to, I think that would be an exception to parental consent. And then a few minors, parental consent could be waived by court order. So again, there's the rule of getting parental consent for those who are not yet 18 years of age, but there are a few possible legal exceptions to that rule. So I'm going to transition now into talking more about confidentiality, and again, my discussion will focus mostly around Utah requirements that are statutory surrounding confidentiality. Confidentiality is, of course, a primary obligation of psychologists, and it's really necessary for the development of trust in the work that we do. When I think about different processes that I engage in as a therapist, I like to think about their association with ethical principles. Depending on the ethicist that I may be reading at the time, most ethicists would identify 6 or 8 or 10 kind of core ethical principles. And when I think about confidentiality, really most of those ethical principles come into play with our practice of confidentiality, of beneficence, doing good, non-maleficence, avoiding harm, and of course respect for the person's autonomy, our own integrity, truth-telling or veracity, and the responsibility that we have to clients. They all really touch on confidentiality in an important way. Marianne Fisher wrote what I think is a very important article in 2008 about protecting confidentiality rights, and proposed a confidentiality practice model that I'm just going to briefly walk through. The first step is preparation. It's doing things like you all are doing today, taking the time and the effort to think about confidentiality, to review your practices, your informed consent practices, to consult with each other in preparation in this area. The author talks about telling clients the truth up front, obtaining truly informed consent to disclose information voluntarily, to respond ethically to legal demands when non-voluntary disclosures must be made, for example, with mandated reporting. Mary Alice Fisher talks about avoiding the avoidable breaches of confidentiality. So, thinking ahead about dual relationship issues and thinking about our practices and procedures in the agencies where we work, training our support staff, for example, around confidentiality. She also talks about just talking about confidentiality with colleagues. So of these 4 steps, my focus with the rest of our time today is really going to be responding to those, responding ethically to the legal demands that we have when we have the obligation to disclose information that's non-voluntary on the part of the client. And again, we'll be focusing on Utah statutes. In order to do that, some terminology. There are 3 related concepts that relate to this area, that relate to confidentiality, that are somewhat distinct, and I'd like to take just a moment to talk about each. The first is the notion of privacy. So privacy really is a right that all individuals have to decide how they're going to share themselves with another, to what extent they're going to do that, when they're going to do that. So that's a right that all of our clients hold. We may, of course, for therapeutic reasons, encourage their disclosure, but everyone that we meet with has some right to privacy. Confidentiality is, of course, the notion that private information that's shared with us in a professional context will continue to be confidential. So it won't be shared with others. It's a defined client right. And again, there's the rule of confidentiality, as I talked about. There's also these legal exceptions in licensing laws that we'll get to. A third kind of related principle or concept rather is the notion of privilege. Privileges, as it says here, a defined protection held by the client against forced disclosures of counseling information in legal procedures. So privilege really is a legal concept. It's a right that's held by the client. And again, there are exceptions to what's referred to as evidentiary privilege in our Psychology Licensing Act. So getting to some Utah statutes, where do we find Utah's legal definition of confidentiality and its exceptions? We find it in our old friend, the Psychology Licensing Act. The section number is there. I'm going to take just a moment to show you the route that I normally access the Psychology Licensing Act. It's through the DOPL website, the Department of Occupational and Professional Licensing. So if we do that, the DOPL site comes up, and if we go here to select an occupation profession, we'll get a listing, alphabetical listing of occupations. Of course, we'll go to P for psychology. And this is the psychology homepage for DOPL. It is, in my opinion, just a very well organized and well maintained site that incidentally has the applications for certified residents and the licensure application. It has board information and minutes. Excuse me, but for our purposes today here, it also has the link to the current Psychologists Licensing Act Rule and Licensing Act. I'm going to take just a moment to pull this up, just so it doesn't scare you. This is your friend. You should read this from time to time. It's important information. There are several parts to the Licensing Act. I'm going to scroll down. I hope this doesn't make you dizzy. I'm going to scroll down to Part 6, down to Part 4, and just show you that that in fact evidentiary privilege and confidentiality is covered here in our Psychology Licensing Act. The next few slides that I have are taken pretty directly from this Licensing Act. So so Utah's rule of confidentiality can be summarized here. So a psychologist under this chapter may not disclose any confidential communication with a client or patient without the express consent of the client or patient. Okay, so we can always seek our client's authorization, their consent to release information. That's the one way that that confidential information could be disclosed. Whether it's the client or with someone underage or who's not capable of giving consent, the parent, legal guardian, or authorized agent. So some exceptions, or actually exemptions then, to confidentiality. Again, the first is if the client gives permission. I've been in more than one conversation here over the years where a few therapists will be talking and there'll be a situation where it would be very useful, therapeutic even, if we could release some information to another party. And we'll sit around and think about, well, how could we do that? Is this an emergency? Not really. It's not a duty to warn. It's and then someone will say, well, has anyone asked the client? And invariably we'll say, no, we hadn't thought of that. So don't forget to just ask your client if you really want to release some information, and they may understand and realize that it's in their best interest to do so. So the other exceptions to confidentiality are those that are permitted or required under law, rule, or regulation. Again, these fall in kind of 4 categories: child abuse and neglect reporting requirements, vulnerable adult reporting requirements, limitation of duty to warn or duty to protect. And then Utah is unusual, I think, in that it has a broad obligation by code, by the Utah Code, of reporting a communicable disease. So just to let you know, in this first area here, the child abuse, I think I've got about 8 or 9 slides. I think I've got 3 or 4 slides around vulnerable adults. I have 1 slide around duty to warn and protect, and 1 slide around reporting a communicable disease. So I'll need to keep moving right along. Again, there are legal processes under evidentiary privilege that would be an exemption to confidentiality, and then generally recognized professional or ethical standards. So I actually think there's some latitude in terms of the Licensing Act and thinking about possible exemptions to confidentiality. But again, I'm going to focus primarily on these 4 areas of legal exemptions. So thinking about the Utah's mandated reporting, and again, these are all Utah statutes. I've included the titles and codes where applicable. We can ask ourselves, who's required to report child abuse or suspected child abuse? And Utah is what we would call an any person state, in that our code says that any person who has reason to believe that a child has been subjected to abuse or neglect must report, and I've added the emphasis there. So Utah is an any person state. Certain professionals are also additionally required to report. So any person licensed under the Medical Practice Act or the Nurse Practice Act is required to report, but really, as you've seen by the code there on top, any person is required to report. I also believe that professionals in certain occupations, ours included, will be held to a higher standard than just any person. I think psychologists, social workers, teachers are going to be held to a higher standard. Is anyone exempt from reporting? And according to the Utah Code, notification requirements actually do not apply to a clergy member or priest under certain conditions. So I guess this would only apply to us most directly if any of us also identified as a clergy member or priest. But if a confession is made directly to a clergy member or priest by the perpetrator, and it's done, as it says here, under canon law or church doctrine or practice, if confidentiality of that confession is to be maintained, that's actually an exemption from reporting child abuse in the state of Utah. However, if information comes to a clergy member or priest in a confessional setting and via another route, then reporting would be required. So if a person heard about suspected abuse from confession and outside of confession, the same perpetrator shared that information, it would have to be reported. Just to be very clear, psychologists are not exempt from reporting, and physicians in Utah are also not exempt from reporting. So can a report be made anonymously? Under Utah code, the code is actually silent regarding whether or not a person making a report needs to provide her or his name. So it's not specifically required by statute to provide one's name. I would think, as a psychologist, if I'm making that report, I would want to provide my name. I'd actually want to be able to document and to have it be known that I was meeting my ethical and my statutory obligation in making a report. But it is possible for individuals to make a report of suspected child abuse without giving one's name. And there is a stipulation in the code that the name and contact information of a reporter would be deleted prior to any release of that report to other individuals. So what triggers a reporting obligation? This is really the meat of the child abuse reporting statutes. So a report is required when a person has reason to believe that a child has been subjected to abuse or neglect, and when a person observes a child being subjected to conditions or circumstances that would reasonably result in sexual abuse, physical abuse, or neglect. So the question is then, what constitutes abuse or neglect? And here we begin to get into some legal definitions. I had asked Jamie to attach a handout. I'm going to go ahead and pull it over to my screen now. This is something that I prepared based on Utah codes that actually provides definitions, legal definitions of child abuse and neglect. It runs about 3 pages, I believe. I'd be happy to send this to any of you, if you'd also like the slides. But just briefly, I'm going to point out that, again, that abuse here is, is defined as non-accidental harm of a child, threatened harm of a child. Also talks about sexual exploitation or sexual abuse. And then more detailed, again, legal definitions are given regarding bruises, lacerations, burns, various types of injury. Of course, physical torture would qualify as abuse. There's a legal definition similarly of neglect, lack of proper parental care, lack of anything needed for the child's health, safety, or well-being. There's, of course, a legal definition for sexual abuse and exploitation. And again, I'm mostly just wanting to draw your attention to this and letting you know that these definitions exist. I'm not going to have time to go into these in detail, but I think we're probably rather familiar with these concepts. But just know that you can access this information. You can look it up as it's needed. One point that I am going to make that actually surfaced here at the Counseling Center in the past year, we had 2 cases where individuals presented at the Counseling Center, and part of their report in seeking services was that they had intentionally viewed child pornography. And this raised the question of whether that triggered a mandatory reporting obligation. And after a fair amount of consultation, both in-house and with university legal counsel, it was determined in these cases that it actually did trigger mandated reporting. There's a Utah code that says that a person is guilty of sexual exploitation of a minor when the person intentionally, it says, distributes or views child pornography. So that actually triggered a mandated reporting situation. I've been more mindful since then in doing my own informed consent of clients to emphasize that not only child abuse and neglect would trigger breaking confidentiality, but also child exploitation. And this falls as under that definition. So again, these are legal definitions of child abuse, neglect, and exploitation. To whom must a report be made? Reports can be made to the nearest peace officer, which really is just a police officer, or a law enforcement agency, either a police department or a sheriff's department, or the Division of Child and Family Services, DCFS. I think at least the route that I'm most familiar with would be reporting through DCFS. They have a hotline number that's provided here. They also have a very good website. And I'll just quickly take you to the front page of their website. I think there are good summaries of the Department of Health Services reporting child abuse or neglect, frequently asked questions, how do I report child abuse or neglect? There's some information, again, the hotline number, as well as just a number of other, questions that relate to mandated reporting. So I think that's a valuable resource to be aware of. Something that's important as we're thinking about confidentiality and in cases where we're legally mandated to report to break confidentiality, it's important to determine the jurisdiction where the alleged abuse took place. So if that's outside of Utah, then Utah's DCFS is not going to be a reporting venue. Even within Utah, you'll find that it's important to know where the alleged abuse took place in terms of exactly where and to what division you'll be making that report. Again, that's talked about more on that website. Within what time frame shall a report be made? The quotation from the code is immediately. I know that sometimes there are concerns and potential concerns about the safety of children that I think come into play, and the statutory obligation that that's actually in the Psychologists Licensing Act is that it will take place immediately. I think it's worth pausing for just a moment to think about the therapeutic implications of reporting. So again, informed consent is just essential that it happens meaningfully and early. I find it helpful to keep in mind that once a reporting obligation is triggered, that obligation does not vary. Once it's triggered, in my mind, you really can't go back and untrigger that somehow. It's kind of like unringing a bell. It just once it's triggered, you're going to figure out how you're going to make that report in a legal and ethical way. However, I think we can consider how reporting can best be accomplished. Certainly sometimes in some situations it can be appropriate to collaborate with clients about how a report is made. I've actually at times facilitated a self-report on the part of a client to DCFS. I would only do that from my office and with verification by myself. I think it's also important to think about cultural and multicultural factors and how that may come into play. Again, that's not going to alter the obligations that we have for mandated reporting, but I think that we can talk with clients and work with clients and ask them, if this is something that they would like to do with the support of their parent or with the support of another member in their community, perhaps with a faith leader. And we have an obligation to see that the reporting happens when that's mandated. So one other, and I'm just noticing time, I'm going to have to go quickly. One other resource that I wanted to make people aware of is this Child Welfare Information Gateway. I found this very helpful in searching state statutes around child abuse and neglect. You can see that you can go to any state, you can go to any of a number of aspects or areas of child abuse and neglect, click on them, go down here to search, and it will actually call up the statutes that are applicable in that state. So really, no matter where you're practicing, I think this is a nice resource. Okay, so under Utah state law, again, in general, minor children under 18 require parental consent to obtain services. There are a couple of exceptions here in Utah to that general rule. One is around care or treatment for sexually transmitted diseases. Minors can seek care or treatment for actual or suspected STDs at any age without parental consent. So that's an exception under Utah state law. Also, emancipated minors or minors who are pregnant or who themselves may have a child can seek some forms of medical care without their own parents' consent. So if we have a 17-year-old who has custody of a child, for example, he or she can seek some forms of medical care for that child without consent of their own parent. So non-exceptions under Utah state law, minors who are seeking contraceptive services or minors who are seeking an abortion do require parental notification. So if you have a 17-year-old seeking those services, parental notification is required under Utah law. Vulnerable adult reporting, I'm going to go through this quickly, but somewhat similarly to child abuse reporting, a person, and it's really any person who has reason to believe that a vulnerable adult has been subjected to abuse, neglect, or exploitation will notify Adult Protective Services or the nearest law enforcement agency. And as you can imagine, each of these terms above has a legal definition. Just some definitional highlights. So a vulnerable adult is an elder adult or an adult who has a mental or physical impairment that substantially affects their ability to provide protection for themselves, to provide the necessities of life, food, shelter, clothing, carry out activities of daily living, manage financial resources, and so on. There's, of course, a legal definition of abuse when it comes to vulnerable adult reporting. Knowing or intentionally attempting to cause harm, causing harm, placing another in fear of harm. Notice that it's not only actual harm, but it's threatened harm or fear of harm that can qualify. Both emotional and psychological abuse would trigger a vulnerable adult reporting mandate. There's sexual offenses that are defined in another title. Deprivation of life-sustaining treatment. There are some qualifications around that, but that would also trigger reporting requirements. I would think this would be especially important, of course, for those working in geropsychology, working with older adults, working perhaps with adults with diminished mental capacity. It would be over the age of 18. There are legal definitions, again, of emotional or psychological abuse, including concepts like abandonment, exploitation, intimidation, isolation, and neglect. So again, if you find yourself in a situation where you think you may be working with a vulnerable adult. In my own setting, this has only come up 1 or 2 times, but in some settings this would come up routinely. You'd want to review Utah Code 62A. You can actually just Google that and it pops right up. So that would be important to review. Quickly, duty to warn, protect. Utah's requirements, Utah's legal requirements, as defined in statute, are essentially consistent with the Tarasoff decision that many of us may be familiar with. So a therapist has no duty to warn or take precautions from violent behavior, except when that client or patient communicated to the therapist an actual threat of physical violence against a clearly identified or reasonably identifiable victim. The duty shall be discharged if the therapist makes reasonable efforts to communicate the threat to the victim and notifies a law enforcement officer or agency of the threat. And we can't be the subject of actions that might be brought against us if we do this in good faith. So again, Utah's law really does kind of parallel or mirror the Tarasoff decision, and I've only had occasion, I believe, twice to discharge a duty to warn or duty to protect. It's something that I would certainly, only do with consultation and with reviewing our statutory and ethical obligations. But if you find yourself in a situation where a client is communicating an intent to harm another person that's identifiable or reasonably identifiable, we have a duty not only to contact police, but to contact or attempt to contact the intended victim. It's interesting that in the Tarasoff case itself, the psychologist who had seen the client, a man named Podar, actually did contact the police, both verbally and in writing. And the gist of the Tarasoff decision was that was not sufficient, that the therapist also had a duty to warn or to help protect the intended victim directly. Quickly, communicable diseases. Utah is unusual in that it has an unusually broad requirement for the reporting of communicable diseases. So if you look up this Utah Code 26-6-6, it says that really virtually any health-related or medical provider or facility or school or individual with knowledge shall report to the department regarding any individual that's suffering from or suspected of having a disease that's communicable. So again, this is an any person or any individual type of a law. That also applies to psychologists. But, my question about this is practically, I'm not sure how psychologists normally would know of a communicable disease that's not already reported to the departments of health or epidemiology. I don't find myself in the position of knowing of a disease that hasn't been diagnosed, that therefore hasn't been reported to a department of Health. I actually made a call to the Utah Department of Health the other day to ask them about this very thing and about psychologists' duty to report communicable diseases. The person that I spoke with at the department said that she had never received a call from a psychologist, and on the one hand agreed that it seems somewhat unlikely that we would be in the position of having that information firsthand. At the same time, she emphasized that there is this Communicable Diseases Act that applies to all people, and that if we were in that position, we would have an obligation. She did confirm that the vast majority of reports that are received there come from medical clinics, and she said actually mostly from medical laboratories. So that's a little bit about the communicable diseases law in Utah. We do list it here at the Counseling Center on our informed consent form, both on that page that talks about confidentiality generally, also on our service agreement. But as far as I know, Utah is the only state that has a requirement that's quite this broad. So, boy, we are just at 2 minutes to 1. I did not do a good job of leaving time for questions. We might have time, Jamie, just for a question. I don't see anything in the chat box, but is there a question that someone may have that I could perhaps address briefly?
So if you do have a question, please raise your hand and I'll unmute you so that you can ask it verbally, or feel free to type it in the chat box. And sorry, I just realized you maybe didn't hear me. If you have a question, please raise your hand and we'll get it addressed that way, or you can type it in the chat box and we'll get that answered for you.
And again, I realize I really did not allow much time at all here for questions. A lot of material to get through.
So hopefully you do see that you do have a handout there, so you can click on that link and have that for future reference if you would like. I'm not seeing any questions. So they have your email address, so if they're interested in more info, it looks like they can email you.
That's correct. Yeah, you're welcome to email me. I'm happy to share slides, and if it's easier for you to receive the email as a document for me, I'm sorry, if it's easier to receive the handout as a document for me, I'm happy to provide that. So again, thank you so much for investing your time and effort today, taking your lunch hour to learn a little more about informed consent and confidentiality, and specifically the legal exemptions to confidentiality in the state of Utah. So thank you very much.
I do have one question if you have just a minute to answer that.
Sure.
Okay. The question is it acceptable to have a brief written informed consent document to give to the client with a full document available online?
Like a lot of questions that are posed to me when I teach the ethics class, I think the answer is going to be it depends. It'd be interesting to see the brief document. The important thing, of course, is those 4 essential elements of informed consent. It's really, does this really meaningfully inform the consent of the client? Do they understand it? Is it adequate? So it's going to be a matter of degree in terms of how much information is in this, brief document versus the full document online. That being said, we have recently at the Counseling Center gone to a written. We actually have the full service agreement that we have the client read. We go over that with them in person. They sign it. And if they want a copy, we tell them the copy is online. So we actually provide our full documentation. We go over that in the moment, and then we provide it online. So I think something like that could work. I just wouldn't want the brief one to be too brief, and it would just be a judgment call.
Okay. All right. Well, I'd like to thank you very much for providing us with this information. We don't have any further questions, so let's end there. And thank you again so much for your time.